Hello, good afternoon, everyone. Greeting from Yogyakarta, Indonesia. I would like to introduce you the team, the authors of this paper. Mr. Murjiyanto, Mrs. Erna, Mr. Sudiana, Mrs. Debbie Andani, and myself from Faculty of Law, Yogyakarta, Indonesia, Janabodra University, and Mr. Zamri from UKM. We would like to present our paper entitled Legal Protection of Registered Trademarks which are considered to be generic names and can be registered by other parties. Let's get the presentation begin. Trademark regulation in Indonesia is regulated in Law Number 20 of 2016 concerning trademarks and geographical indication. A trademark is a sign that functions as identity and differentiator, which is distinguishes between a goods or service and another trade good or service. The trademark law in Indonesia adopt a constitutive system that the rights and legal protection or trademark are obtained after the trademark is registered by being given in a registration certificate. The consequence of the existence of the rights and legal protection of the registered trademark is that the registered trademark cannot be used and registered by another party without permission or approval of the owner. However, the law provides an exception for registered trademark which later become generic names that can be registered as trademark by other parties. Article 22 of the law. In this study, the problem is based on first, is the legal protection for registered trademark, which are then considered to be generic trademark names, can that be used and registered by other parties? Second, what are the conditions so that registered trademark that is considered to be a generic can be registered as trademark by other parties and not to be considered as violation? Based on Constitutive System, registration is a condition of emergence of the right and legal protection of trademark. With the existence of the legal protection and registered trademark, if there are any violations such as use or registration of registered trademark belonging to another party without the owner's permission, legal action can be taken in the form of cancellation or civil or criminal lawsuit. One of the reasons a sign cannot be registered as a trademark is a symbol meets generic elements that are generic is a nature such as common names and or common symbol that cannot function as differentiators. Then it cannot be registered as trademark. Related to the function of the trademark, which function as identity. A brand that meets the requirement and has been registered means there is a given legal rights and protection so that other parties are not permitted to use and register the brand without the owner's permission. However, in the case of the brand that is initially meet the requirements and has been registered, it may later becoming a sign or symbol that is considered generic or owned by the public. Several example marks that is initially met requirement and were registered, which are the latter considered to be generic sign or symbol, can be seen in the table. Based on Article 22 of the law, an exception is provided that is for the registered trademark that later becoming generic names. Any person may submit a trademark application using the generic names in question with addition of other word as long as there is a distinguishing element. In such cases, to provide legal certainty in the determining whether something is considered generic or not, there must be a clear criteria or limitation regarding how trademark is considered to be a generic sign or symbol. Something that can be used as a limitation of generic brand criteria, including generic brands that have general nature and are considered to be publicly owned refer to terms used to be described brand or product names that are not protected by intellectual property right, such as a trademark. A generic brand is a name, symbol, or a symbol that is commonly used to be referred to particular type of products or service and is not given any legal right or protection. Criteria of limitation that can be used to identify generic or common brand include widely used by the public, generally accepted by the general public to refer to particular type of products or service, does not have distinctive characteristics and a unique identity, and considered common. Common names include brand in the form of words, rumah makan for restaurant and warung kopi for cafe. Common symbols include curl symbol for dangerous goods and the poison sign symbol for the chemical and the spoon and fork for the restaurant and service. Slide 8, conclusion. For the discussion of this problem, the following conclusion can be drawn. The first, brand that is later conditioned to be generic brand names still receive legal protection because even though it has become a generic name, it cannot simply be used and registered by another party, but some terms and conditions must be met. The requirement to add the word that contain distinguishing element and have characteristic or are unique is very strong. Second, the trademark is considered to be generic, can be registered as a trademark by another party that is not considered violation. By adding other words that contain differentiation element and have very strong characteristic or are unique, while the symbol part and is considered generic in considered to be public property and anyone can use it and is not considered a violation. That's all our presentation. Thank you so much for your attention and see you on the Q&A session.